for a change lifestyles concerning of others. And now during this epidemic turned into a world pandemic, coronavirus data and the other virus with a new symbol of monkeypox. The quarantine of still an inmate still not wearing masks or without this throughout this facility, and we are one closed in a closed dorm. Okay, my health and my mistake are concerned. Excuse me, are concerned. Okay, and
All right.
We are about to watch the 2022 parole hearing of a man who served 10 years of his 12-year sentence for doing the worst to a child. We will also go over the appeal, which he had won in court, that takes into account his competency. And it's an interesting appeal to go through. We'll go through.
All right. Please introduce yourself, state your name and DOC number for the record.
right, Jeremy Johnson, 623-427.
Okay, Jeremy, my name is Brendan Kelsey. Along with me is Ms. Jackson, Ms. Wise. We'll explain the process to you. Read some information to the record, have a pro interview, ask you some questions. You can respond at the end. You can make a statement. We'll take a vote. You understand the process?
Yes, sir.
Jeremy Johnson, DOC number 623-427. You are a first-class offender. Parole eligibility date 5/23/2017. You're not eligible for good time, and your full term is 6/7/2024. 12 years. Indecent behavior with a juvenile. Does that sound correct?
Yes, sir.
Okay. How old are you?
33, sir.
How long how many years have you been in jail?
I've been in jail 10 and a half years, sir.
Okay. And 10 and a half years on 12 years, so you're getting close. Tell me what kind of classes have you taken? What have you done while you've been incarcerated?
Have taken the sex offender program, which was at Bayou Dorche Correctional Center, and I have taken the anger management classes.
I see. I only have on here that you took phase 1 and phase 2 of your sex offender treatment. Have you taken anything other than phase 1 and phase 2?
Yes, sir. I took let's see. I took sex offender treatment under what successful was participating in the sex offender program treatment, complete phase 1 through 4 at the Bayou Dorche Correctional Center, and I have the certificates with me that I graduated, and I took anger, and I completed the anger management program, and that was it, sir.
What was the date of that?
The date was stated December the 19th, 2021.
2021. Just got it done. Okay, that's good. Well, you got it done. Now, do you have a high school diploma or a GED?
High school diploma, sir.
What year did you graduate in?
2008. May the 20, I think it was May the 25th at Houghton High School. I was in a special ed education.
Okay, Houghton, yeah, good. Okay. Have you had any disciplinary write-ups?
Yes, I had one disciplinary write-up at the Bayou Dorche Correctional Center. Would you let me explain the write-up whenever asked?
What's the write-up was?
Okay, the write-up was I had a report of a contraband as the determinant of a dorm orderly. I was cleaning the dorm up, and I had extra bleach and to clean up the dorm orderly, and I was I had some extra ones, and I had the right to and they diverted me to court with Ashlyn Johnson and Mr. Lieutenant J.R. Lewis. and remained in the blood and the stuff was on the floors and walls and stuff like that. And so I keep bleach to keep the dormitory clean area, but did not get penalized for it because it had been thrown out. It was thrown out by Ashley Johnson and J.R. Lewis, and they gave me extra duty, but was not they did not give me the extra duty as required as they said they were gonna give it to me. And I had and and further notice, they gave me they let me come back to the dorm and keep my dorm orderly job.
Okay, well, that's good. Well, tell me about your crime. What caused you to do these things? Tell me about. I mean, this is a pretty significant crimes here. Tell me what caused you to do this stuff.
Because they do it. For the further apart, it was just political, and I thought it was. I know it was not appropriate to do so, but it was just the unappropriate way to do it, and I was just not in the fresh of a mind at the time. When I went to as I was during the time of the crime, and I just did. I know it was wrong, and I apologize for my convenience and my statement that what I did was wrong, and I will thank to just go back to, and I'm ready to go back to society. And for further notice, or could you please give me the understanding of what you're trying to say?
I was just asking you about the crime. Why did you commit the crime? It was a bad crime. It was a terrible thing with young children. Tell me what caused you to do those things.
Okay, well, I thought at one point I thought he was at the age older than I was, and I was politically not paying attention at the time or how old he was and how abusive crime could be, and the convenience, and that it was happening. So I had apologized, and I just was sorry for my wrong on my behalf, and didn't know exactly what.
So what did you learn? What did you learn in sex offender treatment?
In the sex offender treatment.
Yeah, what did you learn? You don't have to look down at the papers. You can just tell me what you learned.
Okay, in the sex offender treatment, I learned about the status, how to avoid, or having it's not right to have interact with kids or interactive, and I learned about the courses of the sex offender, and I have learned about they have teach you, and they have teach you the proper status of how to be able to control your fears, how to be able to control your anger, and how to be able to control your sex morality, to be able to do that status again, and to be able to come back to jail again.
Okay, now, are you do you take any type of medication? Are you on any medication?
No, sir.
Okay. What are your plans if you were be released? Where are you going to go? What are you going to do?
I'm going to get a job, and I'm going to attend church. I'm going to do better things. I'm going to
job. What kind of job are you going to get?
I'm going to my brother. He own a construction site. He's so I can be able to get a job with him, or I can be able to help my community, like feeding the needs and feeding the homeless. And
who are you going to live with?
Sir?
Who are you going to live with?
To my
If you're released, who you gonna live with?
oh, my brother Brandon Monroe.
Okay. Staff, do y'all have any input back there? Do y'all have any input on him? Anybody?
Talking to you.
Do y'all have any input for me on him at all? Do you know anything about him, or has he had any disciplines or any issues that we need to be aware of?
I'm not sure because I don't come in contact with them until they come up for court. Let me
Okay.
get some help here.
Okay. All right, that's okay. Thank you. Okay, would you like to make a statement on your behalf?
Yes, sir.
Go ahead, Jeremy.
Okay. But anyway, I thank you for coming to let me participate in this parole hearing. I also thank you for giving me another opportunity, a chance in life, and to be able to become a better person who I was back then, but who I am now today. And my name is Jeremy Johnson, DOC 623-427, the Louisiana Department of Public Safety and Corrections. And I'm gonna read a little something that I have wrote. The board of Your Honorable completed on parole the October 6, 2022 schedule for parole hearing. Dear Honorable Board members, I appreciate this opportunity to come up for this schedule appearance and pray. I am eligible for parole supervision, which I believe responsible preparing myself for this opportunity that y'all have given me. I am orderly and get along with others. I've been incarcerated since my arrest and learned how to read, write, and thinking for a change lifestyle concerning of others. And now during this epidemic turn into a world pandemic, coronavirus data and the other virus with a new symbol of monkeypox. The quarantine of still an inmate still not wearing masks or without this throughout this facility, and we are one closed in a closed dorm. Okay, my health and my mistake are concerned. Excuse me, are concerned. Okay,
All right. Okay, thank you. Staff, you have something to say? Do you know this fella? Or you have any input on this?
How you doing, sir?
What's your name for the record?
Lieutenant Guys.
Do you have any information on him at all as far as any problems, any type of disciplinaries or anything that we need to be aware of?
No, sir. He never gave me any problems since he's been here.
Okay, so he's done well.
Yeah, he done pretty good. He done well.
All right, thank you so much. Thank you. All right, pal, fair to vote. I'll vote first. Jeremy, sounds like you're heading the right direction, man. You're doing some good stuff. You're trying to do right. You know, look, you're getting close to really being released on your full-term date. For me today, I'm gonna have to deny you parole. You do have law enforcement opposition, you have victim opposition, and you know, keep working hard. And make sure you have a really good residence plan and maybe a better plan. Get some with the transition folks and try to get that ironed out. But my vote is to deny today. Ms. Wise?
Jeremy, this is real hard for you. I know it was, but you did a good job. You really showed up and you did good. You did good. But for me, my vote is denied with the recommendation that you get moved to a transitional work program. The thing says that you're eligible for transition work. Give you an opportunity to make a little money before you get out in 2024, the good time date. Because you said you completed your treatment and you got a good institutional record from the staff. But because of law enforcement opposition, the nature of your charge, I just think you need a little more time there. Take care of yourself.
Ms. Jackson?
Hi, Jeremy, likewise, you've done a good job while you're there. But I'm concerned that you don't have any family on the called today, and it's very important to have a strong support system when you get out of prison. You gotta have family who can be right there with you. And so I think you need to kind of work on getting your family on board and have them appear the next time. And you do have opposition from law enforcement and the victims, so my vote today is to deny, but to encourage you to keep working hard.
Right, 3 votes to deny your parole. Your parole's been denied. Good luck to you. And it's 10:56. We'll adjourn at Tensall. Thank y'all.
All right, thank you.
You know, I just wish so badly that he didn't do such a horrendous crime. We'll get into, we don't have really a lot of details, but it was a classic harming of a child. Because I just almost like felt like rooting for him. I don't know. I kind of, it's like, it kind of felt bad. You could see he's struggling. He's has what seems to be a clear learning disability, to say the least. And it's like he's trying, but he has no support. He has nowhere to go. Releasing him, and I'm pretty sure that this is how the board felt. I mean, he served 10 years of a 12-year sentence, and they would release inmates left and right, like this, without blinking an eye. But they see this, I think, on their charts as a clear strike against their parole rate, because the odds that he would come back for a parole violation without any outside support are just really high. I mean, that's not that he's at risk of harming a child again. That was not my takeaway. I think he's just at risk of violating parole. And how do I know that? Maybe he would hurt a child. I really don't know. But I'm saying I don't think that's what the parole board was concerned about. I think they just couldn't release him. If there was a parole project there for him, if he had a lot of family support, they, I think, would have done it. It was, Mr. Kelsey, I think, cracked up laughing there at the end of his speech when he starts reading it from the date down to the, he starts reading everything there. And then he starts talking about, I think, chicken pox, and Mr. Kelsey can't hold it together. But I still was surprised they voted no. I thought that they might have gone for it. Now, Richard, thank you for the info. What's interesting about this appeal is that he won the appeal. So he was initially sentenced to 40 years. Okay. And then he won the appeal and they dropped it down to 12. Now, to be sentenced to 40, he took a plea deal. And now the whole idea is that it says here, Johnny attacks his conviction and sentence for his guilty plea for the crime of attempted aggravated sexual assault. He correctly urges that the Sixth Amendment rights were violated by prosecutorial actions taken against him after he was adjudicated incompetent to proceed and without the court subsequently finding him competent. Isn't that interesting? I mean, I think we could see how that would be possible. What I do like seeing here is that there's an appeal that's actually won. We don't see appeals that are won, and I could, it's easy to see how there would have been prosecutorial wrongdoing in this case. I mean, who takes a plea deal for 40 years anyways for attempted aggravated sexual assault? We never see that. You could do far worse and get just 20 years going on a jury trial. Now here's what they say: the salient early chronology of events. In early June 2012, the defendant, then 22 years of age, was arrested for sexually abusing a child previously that month. They don't say how old the child was. On June 8, 2012, the defendant was provided a lawyer. On October 15th, 2012, the defendant was indicted for the crime of aggravated sexual assault. So first it was attempted, and then they indicted him on the more severe charge. On October 24, 2012, through counsel, the defendant filed an application for the appointment of a sanity commission. Now, this is interesting how they do a sanity commission when, it's not that he's insane. It's more like, But anyways, I don't know, maybe that's just the bucket it falls under. Urging that he was suffering from mental disease or defect, I guess it could be defect, that precluded his ability to understand the proceedings or to assist counsel with his defense. On the date, the trial court ordered the requested sanity commission and appointed 2 psychiatrists to evaluate the defendant's mental status. The physicians disagreed as to the defendant's mental competency to proceed. On January 15, 2013, the trial court noted the differing conclusions and appointed a psychologist to further evaluate the defendant. Isn't that, wow, 2 psychiatrists with 2 different perspectives. What a shock, right? That's the thing. When you get professional opinions, I think the whole thing is a bit of a gimmick, frankly. I do. I think you can have 10 opinions and get 10 different results for so many different cases. On January 15, 2013, the trial court noted the different conclusions and appointed a psychologist for the condition. The 3rd expert found the defendant to be mentally incompetent. So on April 30th, 2013, the trial court issued a ruling that the defendant lacked the capacity to proceed because of mental disease or defect that rendered him unable to understand the proceedings and to assist counsel. And I'll tell you, from what I've seen on this hearing, I saw someone that can understand the difference between right and wrong, even to the point where it seemed almost like he lied in trying to say, "Oh, I thought the person was older," but it could just be slow, right? There's a big difference between knowing right and wrong and being slow. Also, he graduated high school, even though it was through special ed. He's still, and I'm saying this as someone who literally took the short bus to school and didn't graduate high school. I dropped out in 10th grade. So on May 1st, 2013, the trial court signed an order to transport the defendant Eastern Louisiana Mental Health System for evaluation and treatment. On May 30, 2013, the defendant was physically admitted. On October 8, 2013, the Assistant Clinical Director of Acting Chief Executive Officer advised the court by letter that the defendant presented has the mental capacity to proceed as he now understands the proceeding against him and can assist his attorney in defense. So isn't that interesting? They're like, he doesn't understand. So let's send him to a hospital. Okay, we sent him there. He's admitted on May 30th. Now, April, May, June, July, August, September, October. All right, now he understands what he did was wrong and he can help his defense attorney. We saved him. Great job. It's funny, right? Therefore, we are discharging Jeremy Johnson and returning him to the custody of the sheriff immediately. Like the whole thing seems a bit procedural, a bit gimmicky, but I guess what are you supposed to do? I'm not saying this in defense of him, by the way. I'm just saying this in the idea of the system where it's like, no, he doesn't understand what he did wrong because we had 2 professionals. They disagreed. We brought a 3rd. The 3rd said he's incompetent. Let's send him to a hospital. The hospital, they do a miracle. They do a complete miracle. All of a sudden, they get him up to like this like above standard where he understands how they come to that conclusion. Who the hell knows? Now they send him back to the sheriff. On October 29, 2013, the prosecutor sought to comply with the mandatory time frame assigned. Judge was unavailable that day. They brought the judge. This part I kind of lose track of what's going on. The assisting judge had presided over the October 29th sanity hearing. The assigned judge made no finding as to the defendant's competency to proceed. There's no order of judgment competency in his record. This is what I don't get. I think there's some technicality issues with the judges and things, but I don't know. The defendant's due process of trials is not, but the bottom line is that, and I'll put the link in the description. Thank you, Richard. The decree was the defendant. So actually, before I get to the decree, let's look at the conclusion. Because the inadvertent violation of the defendant's Sixth Amendment rights, all trial court actions taken on and after November 12, 2013 are vacated. So I think what it means is that including the amended plea of not guilty and not guilty by reason of insanity, the guilty plea on April 4th, 2014 to attempted aggravated sexual assault, the 40-year hard label sentence without benefits. So basically, because he was deemed incompetent, it seemed that in that period, he still had they amended the not guilty plea and by reason of insanity, and then he somehow took a guilty plea, which they amended to, and you see here the 40-year sentence. I don't know. Should we go up and read it? It's actually quite interesting. We previously held the trial courts cannot even accept guilty plea if there's unresolved request for sanity commission. Even if counsel seeks to withdraw request, the instant facts are oh gosh, this is such an easy word, but when I'm reading it, egregious in that this guilty plea was taken despite the most recent substantive ruling, the finding of mental incompetency by court order rendered April 30, 2012 and signed May 1st, 2012. No officer of the court, neither trial judge intended to do anything but follow the law. The mistake is understandable but must be rectified. Many factors led to the glitch in communication, including confusion about separate charges for separate records, mandatory time frame required, compliance, difficulty, multi-parish, good faith involvement of 2 judges and 2 prosecutors, and the sheer volume of court matters handled. It's pretty incredible that this all happened so quickly, but they fixed it. Because of the inadvertent violations of the defendant's Sixth Amendment rights, all trial court action. So that's how he went from a 40-year sentence to a 12-year sentence. It was remanded, and they basically, it's fascinating to me. It's like, at one point they thought it was so bad that they had to give him 40 years. And then when they someone caught that they screwed up. And as much as I am not rooting for him, it is still impressive to see a defense attorney do their job in this sense and right a judicial wrong. But how they then just say, you know what, it'll just be 12 years, because you could tell they just want to get rid of it. They want it to go away. So they dropped it to 12 years. And then fast forward 12 years later, it's as of March 26, 2024, he's still locked up, but he's going to be getting out in good time or just on his full term date any month now. And then what? So in reality, they just kicked the ball down the road. And I won't be surprised if we see him this year at a revocation hearing. And if we do, I'll put it on the playlist of Return of. That's the playlist for those who come back a second time. And with that,